Welcome to Uncommon Knowledge. I'm Peter Robinson. Our show today, should the Patriot Act be renewed? In late 2001, in response to the terrorist attacks of 9/11, the Bush administration proposed the USA Patriot Act. That's an acronym for the Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism Act. The Patriot Act passed Congress overwhelmingly, but on condition that most provisions in the Act expire or sunset in 2005. Now that 2005 is here, President Bush wants all provisions of the Act extended. Should they be? Or do some provisions represent dangerous and unnecessary infringements of our civil liberties? Joining us today, two guests. Jenny Martinez is a professor of law at Stanford University. John Yoo is a professor of law at the University of California at Berkeley and a former Deputy Assistant Attorney General in the Bush Department of Justice. Former Attorney General of the United States and John Yoo's old boss, John Ashcroft, quote, "Some people think that every time there's a law that freedom somehow shrinks. I submit to you that the law is what enshrines freedom. It doesn't undercut freedom when it's properly done," close quote. Does the Patriot Act undercut our freedoms or enshrine them? Jenny?
It undercuts our freedoms and it needs to be fixed.
John?
I don't think it undercuts them. I don't think it enshrines the freedoms either, but it expands government's powers, that's sure. That's got to be clear.
All right. Before we turn to specific provisions of the Patriot Act, let's talk about the tension between defending the nation and civil liberties as a matter of principle. Let's go back 140 years. Civil War, Abraham Lincoln. Suspended habeas corpus detains more than 13,000 people without bringing them to trial or even producing evidence against them. Lincoln's defense that preserving habeas corpus would have meant, quote, Lincoln's so good to quote, isn't he, that he would have allowed, quote, all the laws but one to go unexecuted and the government itself to go to pieces lest that one be violated, close quote. Now, we begin our discussion of the Patriot Act by asking whether Lincoln did right. What do you think?
Well, it's hard to second guess President Lincoln, but it's also important to keep in context what he did. He did suspend habeas, but he afterwards went back to Congress for authorization to do that. And there were some important limits on the suspension of habeas. There were time limits. So if persons weren't indicted by a grand jury by the end of that grand jury's term, they had to be released. So there was an indefinite detention.
So what I'm trying to tease out here is your fundamental view of civil liberties. Are they pretty close to absolute? Are they sacrosanct in your judgment? Or can they be expanded and contracted as the defense of the country requires?
Well, I think as it's been famously said, the Constitution isn't a suicide pact, and so there are circumstances where we need to strike a balance between individual liberty and the interests of the community as a whole. I think that's hard to dispute.
You don't disagree with a word of that?
No, I think civil liberties clearly, if you look at historically, have expanded and contracted depending on whether in wartime and what's necessary to win the war. I'd also say if you compare this period of history to previous periods like the Civil War or quasi-war with France or World War II with President Roosevelt, we're nowhere near the civil liberty restrictions that existed during those previous wars. And so it is true that I very much agree with Jenny that civil liberties contracts and expands. But in this particular war, the war on terrorism, I don't think we're anywhere near something serious as we saw in those previous conflicts.
Okay, let me ask you this last question before we turn to the Patriot Act itself. Judge Richard Posner argues that civil liberties, and I'm quoting him now, should be curtailed to the extent that the benefits in greater security outweigh the costs in reduced liberty, cost-benefit analysis. All that can be reasonably asked of the responsible officials is that they weigh the costs as carefully as the benefits, close quote. Is that a nice, tight statement of a standard that you'd be willing to apply to the Patriot Act?
I'm not sure that's what the Constitution requires. The Constitution sometimes speaks in more absolute terms, and the Constitution is designed to be a framework that will be applied even in circumstances where there is the most temptation to infringe on individual rights. And so I'm not sure that a simple cost-benefit analysis really is consistent with what the Constitution requires in terms of restrictions on the government.
She is now striking out on her own. After giving you something to agree with, John,
We've got to disagree.
You go with Posner here?
Yeah, and the problem is, and I think this is the argument civil libertarians make, is that we just don't accurately measure the costs of the civil liberties violation. So when you measure benefits against costs, it's very easy to see the benefits in wartime because they're immediate.
Right.
The costs might be longer term and we can't measure them well. I think in this war, actually, I think we've thought a lot about it, a lot harder than previous conflicts, about exactly what are the long-term costs of civil liberties of doing different things.
Okay, let's turn to several of the most controversial provisions of the Patriot Act itself. Section 218, which amended the 1978 Foreign Intelligence Surveillance Act, or FISA. You will now tell us how the law stood under FISA, and then tell us what Section 218 of the Patriot Act did to FISA. Will you please?
Yeah, and let me say before I do that I worked on this particular section, but I'm not saying anything secret or classified about it. And I also was present at the case where this change was argued before a special FISA court, which we could talk about later. But before the Patriot Act, one got a FISA warrant, the Foreign Intelligence Surveillance Act warrant, based on probable cause that someone was an agent of a foreign power.
Warrant to
conduct search, tap phones, read emails, bug people's residences, all in secret.
Right.
And usually based on classified information that someone was a spy. Now, the laws that stood before required that the primary purpose of the surveillance was to gather what's called foreign intelligence information. The Patriot Act changed that language to significant purpose. And the reason for that is a very long, complicated history, but essentially the reason for that was because under the previous standard, the courts and the Justice Department across several different administrations built this famous wall we've heard about, the wall between foreign intelligence and domestic law enforcement. So for example—
And they built that wall why?
Because they thought that this primary purpose language under the pre-Patriot Act standard required them to keep those two functions of our government separate. So to give you an example, if the government got a FISA warrant to surveil someone they thought might be a terrorist domestically, they could not share that information with the CIA or the NSA unless they thought the guy was actually going to commit a crime.
Right.
And so that barrier, which was criticized by pretty much everyone who's looked at 9/11 now, including the 9/11 Commission, was changed by this part of the Patriot Act. Doesn't seem so obvious that it changes it, but that was the primary purpose of the change in the statute.
Of Section 218.
Of 218 was to get law enforcement and intelligence agencies to share information, because as we saw in 9/11, terrorists cross our borders. There's no difference between domestic and foreign anymore.
Sweet reason. Obvious change needed to be made. Correct?
The problem is that I think that Section 218 was neither necessary nor sufficient to make that change. I think everyone would agree that it's important to break down the barriers between different agencies of the government that weren't sharing information before. But, for example, the 9/11 Commission found that it wasn't defects or lack of power in the law prior to 9/11 in terms of surveillance that caused the intelligence failures. It was a misunderstanding by the agencies involved of what powers they had, and the wall requirement is not something that the prior law actually required.
They misapplied the prior law?
Yeah, it's clear. You could say, well, the original Texas statute didn't really require the wall, but not just the agencies, but the federal district courts required the wall because of that provision of the statute. So after 9/11, you have to pull the wall down by changing that language in the statute. And I'll give you an example. This actually made a big difference in the case before 9/11 that could have made a difference. So you've heard about this case of Zacharias Moussaoui.
Right.
The guy was in Minnesota who the FBI found out was involved in the 9/11 conspiracy because he wanted to learn how to fly planes, but not land them. And when they caught him before 9/11, he had a laptop computer. And we found out after 9/11 that laptop computer had plans about flying planes into things using crop dusters and so on.
But the FBI
and they would
did
not search his laptop.
Oh, they wouldn't search the laptop.
Because of the standard in the statute.
Okay, so what is your argument, that it was unnecessary, that they were simply misinterpreting the laws
What the
already
9/11
stood?
Commission found was that there was misinterpretation and misunderstanding of the powers that the government already had. And I think, more importantly,
let
the
me
law
ask you—
doesn't, the fact that now you can have these expanded powers to conduct searches and seizures independent of the sort of normal protections that you have for that doesn't mean that there's going to be communication among the different intelligence agencies or law enforcement.
How do we evaluate the ways in which this law has been used since it was enacted in 2001,
Well, that's
Section 218?
That's a real big problem, because the government has said in response to public congressional questions and in response to requests from different groups that most of the information about how these laws are being used is classified, that there can't be public debate. An evaluation of how well they're being used.
Department of Justice, however, has to reveal this information to at least a couple of committees in Congress, right? That's the oversight
That's correct.
structure?
They do.
Right. Well, this is really a fight about Senate committees and their jurisdiction, because the Justice Department and the CIA and the NSA all report this information and how these powers are used in the information, where it goes to the intelligence committees and is classified and it's closed hearings. That's the way it's been ever since 1978. Now the Judiciary Committee wants to know that information too, and they want to have it more public. And the agents are saying, look, we've never done that. We're not required to under the statute.
I want to get
so
to
why
another
should
couple
we?
of sections. So let me ask, you're now not lawyers, but you're members of the Senate, let's say. Let's give you an esteemed position. Are you going to vote to extend Section 218 as it is, to amend and extend, or to permit it to expire?
I would permit it to expire.
John?
I would vote to extend it, as I think many Democratic senators will, including Senators Feinstein and Biden.
All right. On to the Patriot Act, Section 213. Section 213, so-called sneak and peek, authorize the use of delayed notification search warrants, which allow the police to search and seize property from homes and businesses without telling occupants until later. Former U.S. Attorney and Congressman Robert Barr, conservative in Congress, quote, "The Justice Department often claims that the use of such warrants was common before. Courts, however, put specific checks on these warrants. They could only be authorized when notice would threaten life or safety, endanger evidence, or incite flight from prosecution. The Patriot Act greatly expanded such justifications," close quote. Are you happy with 213?
No, I'm not, and I think it's representative.
Is that a fair
I
statement of
think
what's
that-
wrong with it?
I think that is a fair statement, and I think it's also relevant that an overwhelming majority of the House of Representatives, including some very conservative Republicans, voted in an appropriations bill to change the sneak and peek warrant requirements because people on all ends of the political spectrum view it as a dramatic departure.
Okay, now let me ask you, do they somehow object in principle to something that they thought was a delightful idea in 2001, or do they have specific evidence that it's being misused?
Well, I think it goes back to the general problem with the Patriot Act, that there wasn't adequate time in Congress for consideration of some of its more controversial provisions, that it was passed on a rush schedule without the kind of normal House and Senate reports and debate that you would have with normal legislation, which means that some of them may not have thought it through before they voted for it the first time. And again, in terms of monitoring how exactly it's been used, it's another situation where we don't have a lot of public evidence about how it's being used, and so...
So the objection, more or less, your objection, the objection in Congress, is really to Section 213 on its face. People don't know. People don't know how it's being used.
I think it needs to be scaled back to be more in line with what had been the practice in the courts before the Patriot Act. So in terms of time limits for how long the government could keep the search secret, members of Congress want to restrict that to 7 days with the possibility of extension.
John is giving us some very nice reaction shots. He's looking puzzled and querulous. All right.
Well, I just think about the practicalities of this, right? And this, I think this gets to one of the primary confusions about the war on terrorism is terrorism a crime or is it war? And you see a lot of people, I think many of these arguments are, we should use the same standards we use for the criminal justice system and apply them to terrorism, which I think failed, and we saw that on September 11th. And let me give you an example in this particular context. Yeah, we do want to give notification to people that they're being searched, that they've been subject to warrants. But do we want to do that with terrorists, right? The practicality of it is, don't we want to follow terrorists around for long periods of time without them knowing, so we can find out who else they're connected with,
There's
the
nothing
network.
in the law that limits it to terrorists.
The FISA statute is limited to terrorists and spies, right? It's not, it doesn't apply to drug dealers, it doesn't apply to normal drug crimes, it doesn't apply to garden variety
Not
federal
all
crimes.
the sneak and peek stuff.
No, but well, there's other sneak and peek ones which are used in other contexts, but which weren't created by the Patriot Act. The Patriot Act, even amending FISA, only applies to foreign terrorist organizations, agents of foreign powers, right? And I mean, there's a list in the FISA statute. It doesn't apply to all federal crimes.
Would you vote to amend?
No, I would keep it the way it is.
You think it's fine the way it is?
Yeah, I think it's fine the way it is.
You would vote to amend or let it expire?
I'd vote to amend.
You would? Okay,
Yeah.
so it's important to be able to do some snooping, frankly. You just want it done under stricter
Absolutely.
oversight. Let's discuss one more controversial section of the Patriot Act. Section 215. Prior to the Patriot Act, the government needed at least a warrant and probable cause to gain access to private records. Under the Patriot Act, third-party holders of records, including libraries, holders of library records, financial, travel, video rental, telephone, medical records, can now be searched without the knowledge of the subject as long as the government can claim that it's preventing or pursuing terrorism. That's a fair summary of the way you understand Section 215? And what do you think about it?
I think 215 is problematic because it doesn't require that there be any specific or articulable evidence that the individual whose records you're seeking has any connection to terrorism. So without making any kind of claim or showing that I have a connection to terrorism, they can go to my public library, they can get the records of the books I've taken out of the library or the books I bought from a bookstore. They can go to my doctor's office and get my medical records as long as it's pursuant in some broad sense to an investigation of terrorism or foreign intelligence, with nothing at all to say that I have anything to do with terrorism.
Section 215 is an invitation for the FBI and others to engage in fishing expeditions, John.
Well, it does require that the search be relevant to a terrorism investigation. It's not an
As
open-ended...
adjudged by whom?
By what's called the FISA court. The FISA, it's a federal district court. They issue the warrants and they judge whether the warrant's applicable in any case. And it has to be relevant to a terrorism investigation, not, you know, let's just randomly search 100,000 people's records to see if any of them might be a terrorist. Now, it's not the same as being a target or a suspect, but it is someone who's relevant to a terrorism investigation. The second thing I'd say...
There's a requirement that the individual be relevant to the terrorist investigation.
No, but the search has to be relevant to terrorism
Can I ask, the
investigation.
FISA court, regular, so these folks, the judges who sit on that court are appointed by the President and confirmed by the Senate in the usual manner.
Yes.
Do we have any statistics, gross statistics even, about ratio of warrants issued as against requests for warrants? Do we know anything
Yes.
that goes on in the FISA court?
Yes, the FISA court is actually staffed by existing federal judges whose day job it is to just hear normal cases.
Oh, I see.
Yeah, so a federal district judge in Washington, D.C. is usually hearing criminal cases. Civil cases can be assigned to the FISA court, and that's sort of their night job, too.
I see.
Which is good because they bring to them, therefore, their experiences in other areas of criminal law.
So it's not as
civil
if you
law.
have a separate bench
No,
that
you don't. They're all existing
lives in
federal judges.
secret for 20 years or something like that. All right,
And
all right.
from what we know, the FISA court, until 2002, had never rejected the government's request for a FISA warrant, which is because instead what they would do is say, you need to fix this and submit it again.
I see.
And actually this allowed the FISA court to exercise a lot of oversight over the way the Justice Department and the other agencies used FISA. So we actually have a fairly good statistics. They are publicly known. So, you know, obviously after the Patriot Act, there's been a lot more warrants issued than there were before the Patriot Act, which I think would be justified after the September 11th attacks. But this FISA court is very well known for being independent and being very tough on the Justice Department. And actually the
You grant that? That's the reputation of the FISA court?
I think there's not enough public information for me to be able to say what the FISA court's really doing. I mean, Mr. Yu's been there, and I haven't.
John, let me ask you a related. Next, how does public sentiment bear on the debate over civil liberties versus national security? One aspect of applying this Posner standard, of trying to weigh the costs and the benefits, could be that you just have to, if you're the Attorney General, you just have to try to take into account the political outcome from some of these measures. So it could very well be that Section 215, in some sense, it does advance the war against terrorism. But on the other hand, the ACLU has been in a constant lather about it ever since it was enacted. Jenny's upset about it. It's very difficult to get enough information to satisfy Jenny Martinez, the ACLU, and large segments of the public. So isn't there some sense in which you might almost want to argue, look, that one hurts us more than it helps us?
Well, the librarians one is a good example. You know, so the ACLU got librarians to raise a big uproar. Turned out the Justice Department never sought a warrant under this section for a library at all.
Well,
so there's a lot of...
That's what they said as of
the date they did it, yeah.
As of the date they did it. And subsequent surveys have shown that some libraries say they have received such warrants.
Yeah, I don't know how that's
Which,
possible.
Since it's supposed to be secret.
Yeah, they're not allowed to say that.
It's supposed to be secret, but in any case.
But I mean, the thing, you make a very important point, is that sometimes we rely too much on the courts to be the check on what we do in civil liberties and wartime. And the point you're making, and a very important point, is that the executive branch and the legislature check themselves and check each other without involvement in the court. So an attorney general who might be concerned about the Fourth Amendment issue and privacy rights might order that we not use the FISA powers and the Patriot Act powers as broadly as we can. And I think that's true of libraries. There has not been a lot of use of in libraries.
We just don't know, right? They're not telling us. And if a library is served with a request, they're supposed to keep it secret. It's a crime for them to tell, although I have seen survey data that shows that some of them have claimed to receive them.
But what's going on here is that the way this is all structured places an increased importance, a quite dramatically increased importance on the oversight committees in the House and Senate. Is that not correct?
Yes.
And so are you Is the ACLU, is somebody beating up on them? Is there any way for the public to satisfy itself that these men and women on these oversight committees are up to the job, that they're stepping up to the new importance of their position?
I think one of the things in a democracy is you need to have the possibility of some public debate, where it's not just a Senate Intelligence Committee sitting in closed session talking amongst itself, but where you have the ability for our representatives to have a public discussion.
I think that's a nice principle when you're not in a war. That's the principle that applies to all other forms of legislation, right? But in wartime, and certainly during the Cold War, we made the judgment as a society that there's some things which are better kept secret now, maybe publicly known later. Otherwise, we wouldn't have a CIA. We wouldn't have covert operations at all.
But
So
how can
Section
we
2,
just-
let me, because we're going to a broader debate, which I want to. But on Section 215, you'd let that one expire? You'd amend it? What would you do?
I think it should be amended to require that there be some specific articulable suspicion that the particular individual whose records are being seized has some connection to terrorism.
Sounds reasonable.
I would just make it that the documents or information you need are relevant to terrorism.
All right,
not
so
that
you would
the
simply
person.
extend it in its current form?
Yes.
All right. Now,
Finally, why John Yoo thinks both the right and the left have mischaracterized the Patriot Act.
quoting John to you, the Patriot Act debate reflects a mutual accommodation between left and right to avoid airing the challenges of the new terrorism. This debate may be reassuring, but it reflects a politics as usual attitude that avoids the hard issues before us. John, explain yourself.
Well, I think both the right and the left exaggerate what the Patriot Act really does. Patriot Act is just a bunch of amendments to a law we've had for 25 years called FISA. And I think it's very reassuring to have this great national security versus civil liberties debate over the Patriot Act. But the Patriot Act doesn't do a lot more. I agree with Jenny, it may be helpful in some circumstances to capture terrorists, but it's not going to stop al-Qaeda. It's not going to stop al-Qaeda from trying to attack the United States. It might help us stop a plot, maybe if we're lucky, but it's not going to really confront the fact that terrorism and al-Qaeda in particular are very different.
And the
than what we've
hard
done
issues before us are?
We're fighting a non-state terror actor, and we've used criminal justice methods before, and they failed. How do we deal with them? We can't bomb their cities. We can't attack their populations. They don't have any armies.
Okay, now brace yourself for this next quotation. He has said in print, in the same article from which I've already quoted, that we need, the legal community needs to address questions including targeted killings, collective sanctions, preventive detention, and aggressive interrogations, right?
Yeah.
And if we're serious about terrorism, not only the political system needs to step up and consider these things, but the legal field needs to get its arms around these as well. You
If we
agree?
look,
I agree absolutely, and I think,
But your view would be he's a madman. What we need to do is make sure that he can't do those things, right?
yeah, I think Congress has really dropped the ball. And well, I don't know. I think John may be a madman, but you know, I think Congress has really dropped the ball in the broader legal community. I'm not sure I'd agree on that, but Congress in particular, in addressing some of these issues like detention of individuals at Guantanamo or here in the United States, about treatment and interrogation of detainees, about military commissions, where Congress just hasn't come in and done anything. And so I guess I agree.
these are all things that other countries have done
Yeah,
to
right.
respond to terrorism. It's not like, you know, we made up a list of things.
And John is suggesting that the nation is at war and that the legal profession has its eyes closed. They're just not helping the way they ought to. Is that that's roughly your argument?
Yeah, and in fact, I think a lot of it is because we expect the courts to do it all for us. It's something we've talked about on this show before. Everyone just, and Jenny's litigated some of these cases. I've been in some of them. We just expect the courts to decide it all for us, and that precludes us from having a debate. But we as a society should make our decisions on each of these policy things we can do to beat terrorism, not wait for some judges to decide it for us.
I think what the experience of other democracies like the UK and like Israel show is that you need all three branches of government involved. You need the executive branch, you need your legislators, and you need the courts.
Yeah, but what he's saying is, if I understand John, he's saying implicitly, Jenny, look, next article you write for an academic journal, why don't you consider the pros and cons of targeted killings? How does that sit with you?
You know, I've actually been at conferences where that's been discussed, but for example, on the issue of preventive detention, I have written about and I've argued in the courts about the legislation in other countries like the UK and Israel on preventive detention. And what I told the Supreme Court in the Padilla case was not, you ought to make up all the rules on this, but that unless Congress comes in and provides some guidelines, the executive
Let me round this-
branch shouldn't do this at all.
Final question, television. We have to tie it all up. President George W. Bush on February 14th, quote, "To protect the American people, Congress must renew all provisions of the Patriot Act this year," close quote. Prediction now. Will the president get what he wants? Jenny?
No, I predict not.
They're going to amend
I
it.
predict they'll make some amendments.
John?
I think functionally they'll keep it in place. There might be some cosmetic changes, but I think it's going to be very hard for congressmen or senators to vote to restrict the Patriot Act's powers in the middle of a war.
Jenny Martinez, John Yu, thank you very much. I'm Peter Robinson for Uncommon Knowledge. Thanks for joining us.
We welcome your comments on this week's show. Our email address, comments@uncommon